To introduce our speakers today, I'll turn things over to Professor Judith Dar, Chair of the ASRM Ethics Committee.
Thank you so much, Jessica, and welcome everyone. Thank you so much for being with us on this lovely summer day. As Jessica said, my name is Judy Dar, and I have the privilege of chairing the ASRM Ethics Committee currently. And for those who don't know, our committee is comprised of a multidisciplinary team in which we meet regularly to develop, write, and publish policies and opinions in the field of reproductive medicine with the sole goal of providing guidance and wisdom to our members. So that summarizes to some extent what our committee does. And one of the policies that we have published in the past occupies the topic for today. So let me briefly introduce it and then talk about our wonderful speakers. Today's topic is much discussed and is of vital importance to all the stakeholders in our field, as well as we think to society at large. The welfare of offspring born through assisted conception is of extreme interest and can at times present a dilemma for providers who occupy the rare position of having control over the reproductive lives of others. A provider's decision to offer or to decline to offer fertility services to prospective parents on the basis of their anticipated child-rearing capabilities or perhaps lack of capabilities is an enormously complicated area that our members have expressed interest in learning more about. So we bring you today's webinar in order to facilitate that discussion. Today, each of the speakers brings a unique and important perspective to this arena, hailing from the clinical, legal, and ethical aspects of ART practice. So let me go ahead and introduce the speakers in the order in which they will present. First, we have Lynn Westphal. Lynn graduated and earned her medical degree at Stanford University. She did her residency training in obstetrics and gynecology at UCLA and Stanford. She further did a fellowship in molecular biology at Stanford and completed her fellowship in REI at UCSF. Dr. Westphal joined the full-time faculty at Stanford in 1998 and is a professor in the Department of OBGYN. She is the Director of Fertility Preservation Programming and the Director of Third-Party Reproduction Programming, the Director of the REI Fellowship, and co-director of the Women's Health and Sex Differences Scholarly Application. And her interest in fertility preservation for cancer survivors led her to set up one of the first oocyte cryopreservation programs in the country back in 1999. And she was Director of Women's Health at Stanford from 2005 to 2012, and then co-founded the Stanford Center for Health Research on Women and Sex Differences in Medicine. And I'm happy to say that she is a vital member of the ASRM Ethics Committee, having joined in 2015. Next, we'll hear from Josephine Johnston, and she'll speak to us about child-rearing abilities and the ethical and policy considerations that surround this topic. Josephine Johnston is the Director of Research and a research scholar at the Hastings Center, which is an independent bioethics research institute in Garrison, New York. She's an expert on the ethical, legal, and policy implications of biomedical technologies, particularly as used in human reproduction, psychiatry, genetics, and neuroscience. Josie's current projects address the ethical implications of prenatal tests, gene editing, and psychiatric, neurologic, and behavioral genetics, as well as the use of genetic sequencing technology in newborns. She holds a degree in law and bioethics from the University of Otago, which is in New Zealand. And welcome, Josie. We're thrilled to have you. Finally, we'll hear from Lisa Reinhardt, who will speak to us about the legal considerations in linking child-rearing capability with fertility services. Lisa is a nurse attorney, and she currently serves as a risk management consultant and practice management coordinator, and she's been involved in reproductive medicine in the Chicago area for the past 25 years. She's also been very active in her volunteerism and participation with ASRM. She's been a member for over a decade. She served as chair of the Association of Reproductive Managers and the LPG, the Legal Professional Group, and currently serves as chair of the ASRM Membership Committee. She's a frequent speaker at programming, so I'm sure many of you have met her at our annual conferences or congresses, as we now call them. Welcome to Lisa. We're just delighted to have you here. And before I turn it over to Lynn, just reiterate some of the housekeeping tips that Jessica went over. Each of our speakers have slides, and they'll present those slides to us and do so in about 12 to 15 minutes each in the order that we just introduced them. And we do welcome questions throughout the presentation that can be typed into the chat box in the gray toolbar at any time. And then finally, as just as chair of the committee, I thank you so much for attending our quarterly webinar series and invite you to communicate with me or any member of the committee as to topics that you'd like to see considered and discussed in the future. So with that, I'm happy to turn it over to Lynn.
Thank you. It's a pleasure to be part of this presentation today. And Judy, thank you for getting us all together. I'm going to be discussing clinical considerations on this topic, and I have nothing to disclose. At the conclusion of this presentation, I'm going to explain the importance of not denying fertility services on the basis of disability, discuss the ethical obligations in treating or not patients who may not be able to provide adequate care for children, and describe the role of the fertility program in the assessment of the child-rearing capacity of patients. Fertility programs may see patients who do not appear to be able to provide safe or adequate care for children. And there are a number of areas of possible concern. Psychiatric illness, I think, is a common thing that may come up. History of violent or criminal behavior, child or partner abuse, substance abuse, or mental or physical limitations. The dilemma for fertility providers is that fertility treatment is usually focused on medical aspects of reproduction. Patients who could cause harm to a child can present for treatment. However, there is no child yet to be harmed. And if no treatment is provided, no child will be born at all. Child-rearing ability is not a standard part of fertility assessment in the U.S. And clinics typically focus on medical aspects. Fertility providers usually are not trained to evaluate non-medical issues and may be uncomfortable with restricting access and making social judgments. No screening is required of people who reproduce without assistance, so the concern is that there's unequal treatment of infertile patients and having a dual standard for parenthood. The question then is, what is the role of the fertility program in determining competency to parent? Fertility treatment involves actively assisting procreation, and there are a number of different ways of doing that, and there is use of sometimes very expensive resources. So should the providers factor in the treatment risks or the complexity of care, and should provision of care depend on the option used? Should it make a difference if they're doing intrauterine insemination or in vitro fertilization, or using a third party? The type of treatment may impact the type of evaluation that the patient is undergoing. Third-party reproduction typically involves more in-depth assessment. Patients usually will meet with a counselor. There may be agencies and lawyers involved. This may result in more information being disclosed about the patients, and may also need to take into account the opinion or comfort level of a third party, such as a surrogate. In the first case, there was a married couple that was planning to use a gestational carrier, and during evaluation, it is revealed that he had been convicted of rape a year ago. This information was found out by the clinic because the agency was doing a background check and found out this information. In the second case, there was a 35-year-old who was planning donor insemination. She wasn't working. She was getting welfare benefits, lived alone, had no obvious social support, and had some serious psychological issues. There was concern about the psychological issues, but by having criteria for parenting, there also was a concern that could discriminate against certain groups, such as patients who have a non-mainstream lifestyle or patients who are poor. It's possible that by being economically secure, patients may be evaluated differently. There obviously is a very deep value attached to parenthood, and this prompts a very wide range of individuals to seek treatment, including those who may not appear competent to be parents. Physicians may feel that they need to respect this right above all and provide treatment. In other words, their primary responsibility is to the infertile patient who is receiving treatment. Providers may feel that everyone has a right to a child and they cannot turn someone away. On the other hand, some practitioners may have a significant non-arbitrary reason to believe that a patient as a future parent would be unsafe. Programs may refuse treatment if they think significant harm to a future child is likely. For example, a program may choose to refuse treatment if a patient has been physically abusive to an existing child. Before refusing treatment, an investigation should be done and determination made by a multidisciplinary treatment team. Evaluation may involve a mental health professional or consultation with other experts to make a careful decision. Programs should develop policies for assessment so that all patients are treated equally. Having policies in place will just decrease decisions that could be biased or discriminatory. If treatment is refused, the patient should be told why they were refused. If there are other options, those should be discussed, and if appropriate, refer for counseling or other support services. Reproduction is a basic human right, so careful consideration must be taken in making decisions about whether to provide care. Providers must try to treat all patients equally and be aware of potential bias, and must be very careful to not discriminate based on race, ethnicity, religion, sex, disability, sexual orientation, and gender identity. Patients with disabilities should not be denied access to fertility treatments just because of having a disability. If patients do deny a case, they should assess their reasons and ensure that it is not discriminatory. Prediction about parenting ability of patients with disabilities are especially prone to error and bias. Even when patients' disabilities affect their ability to parent, they may compensate for these deficiencies with the assistance of family members or friends. The birth of a child is usually deemed a good in itself. Decisions about providing treatment determine whether a child will be born at all, not whether they will be in a safe home. Providing treatment allows time to contemplate potential risk to a child. Programs may require patients to meet with a counselor. During fertility treatment, there also is time for other experts to be consulted. So depending on the situation, a program could refer a patient for a second opinion or have the patient reevaluated at a later date. In the U.S., there are no guidelines for determining the welfare of a prospective child. In the U.K., the HFEA requires that all patients be evaluated for the welfare of a child born through treatment, and this will be discussed a little bit later in more detail. There is a wide range of approaches to parenting, and children can thrive in many different situations and many types of homes. There must be a very large deviation from good enough to raise concerns, and it's very important to be sensitive to cultural differences. The primary concern is harm to the child, but there is a cost burden to society from parental unfitness, and that is a worry that some programs may have. Physician and professional autonomy is an important value. Fertility providers are usually free to provide services as they choose, as long as state and federal laws are observed. There are two aspects of autonomy in these situations. Providers may choose to not treat if they have a significant concern about the safety of a child. On the other hand, providers may believe that they have an obligation to treat all patients and not assess a patient's child-rearing ability. So in conclusion, for this part of the presentation, the interests of a future child can be taken into account when providing fertility care. The program does need to balance the right of a patient to create a family, right of physicians to not treat when they think harm outweighs benefit, and harm to the offspring. Providers may decide to treat or not, but treatment denial should be based on a fair assessment, and development of program policies can aid in standardized, non-discriminatory evaluation of patients.
Thank you, Dr. Westphal. Ms. Johnston?
Okay, so I work at an independent research institute that's focused on bioethics issues, and I don't have any financial relationships relevant to this topic. So I'm going to cover many of the same issues, but maybe with a slightly different take than we just heard. I'm going to explore the nature and magnitude of the problems that I think the guidance on these issues is trying to get at, and sort of maybe try to tease them apart a little bit. Trying to identify policies and practices for addressing the problem. And I'm going to look a little bit more closely at what the UK does and how that's different from what happens in the US. And I'm going to discuss, just put out there some questions that I have about the scope of providers' responsibilities in this area. So when I ask myself what is a guideline like this really trying to get at, I think there are in a way at least three concerns that a guideline like this is addressing. And the most obvious one is the risk of harm to or the neglect of existing or future children. It's important to note that there might not yet be any children in the family, but there might already be children, and so there could be concerns about existing children as well as any future child. So that risk of harm or neglect is a real concern. I think the other thing that might be driving this is a kind of moral distress that providers could feel at providing services to parents who raise concerns. So it's likely that the experiences of providers and their staff are part of the reason for this, there needing to be this kind of guidance. And there's a public-facing aspect, I think, to this as well, that presumably ASRM and its members have a concern that the public trusts that fertility providers and fertility medicine is not reckless as to the health and safety of children and future children. But I do think that there is not a great amount of data out there on this issue. So there's certainly data, national data, on the rates of harm to and neglect of children in the US, and about 650,000 children a year are judged to have been subjected to abuse and neglect, but there isn't, that I know of, any data specific to families who use fertility services. So I don't have a sense of how frequently providers are struggling with this issue, of how often services are withheld, or of how often families who use fertility services are found to have been abusive or have abused or neglected their children. So I think it's interesting that it's such an important topic, felt to be an important topic by providers and by the organisation, but there isn't really a lot of data on the other side to answer how big a problem this actually is. So it'd be interesting to know more about that. as we just heard, one of the objections, there are a number of objections to fertility providers making this kind of assessment. So concerns about the reproductive liberty, autonomy of the families or the patients, that they have a right to be able to have children and that nobody should be second guessing that. And certainly there's this concern about the differential treatment of fertility patients when compared with people, what I've called here people who are reproducing in the wild, people who are don't need the help of fertility providers. I understand this concern, but I want to point out that there is this sort of naturalistic fallacy built into that, which is that just because patients, potential parents in the wild, people who do not use fertility services, just because they are not, no one prevents them from reproducing if they have a significant risk of harming a future child. Just because that happens anyway doesn't mean that it's okay for physicians to do the same thing in their clinical practice. So yes, it's true that nobody subjects people to a parenting test in advance of them producing without assistance, but that it by itself doesn't tell me that it's a bad idea for there to be some sort of mechanism for withholding care if significant concerns arise in the fertility context. And certainly, you know, I don't think we would want medicine or medical professionals to be in any way implicated in creating a situation in which children are put at risk. So there is, I think, some justification for feeling uncomfortable about this, but also for attending to this issue. But as we've heard, you know, the ART providers are not necessarily people who have the expertise, the training, or the resources to make really detailed and careful assessments, and it's not clear whether those assessments are necessary. So how much should providers be asking about? How deep should this obligation go, I think, is the relevant question. And there is also this history of some discrimination in fertility provision and with single women and gay and lesbian patients being denied services in the past, and there is of course a potential to make mistakes, so for services to be withheld on the basis of concerns that turn out to not actually be pertinent. Nobody is perfect, and people with a history of wrongdoing or mistakes or people with mental illness or disabilities can easily be discriminated against if we go too far with this obligation, with this responsibility. So I want to stop for a second and look at what the UK has done about this. So of course the HFEA'S are really different and an interesting entity in the UK, and their way of dealing with all issues around assisted reproduction are really different in terms of the legislative and governance structures that they have in place. So as many of you probably know, the HFEA and the Act, the Human Fertilisation and Embryology Act, has had a child welfare condition in it since its inception. And when it was passed in 1990, the condition said a woman shall not be provided with treatment services unless account has been taken of the welfare of any child who may be born as a result of the treatment, including the need of that child for a father and of any other child who may be affected by the birth. So in here we can see similarities with the guidelines that ASRM has insofar as they're interested in they're allowing for the withholding of services if there are concerns about a future child or an existing child. I think some of the big differences here, though, and I'll talk about the need for the father part in a second, but some of the big differences in the basic provision are that they ask for providers to take account of the welfare of children. And that is really different, I think, and much more demanding standard than the US standard, which is to withhold services only when there's a risk of significant harm. So assessing child welfare and significant harm are, you know, on the face of it different. So I think this obligation goes a little bit further. Now, unsurprisingly, and as many of you may know, there were concerns that the provision as written was discriminatory, especially the part requiring that providers take account of the need of that child for a father. So that was debated in the UK. It was debated because it was in the legislation. There was going to be a change. It would have to go through Parliament. So it was debated. The House of Commons Science and Technology Committee report in 2005 specifically raised concerns about discrimination in the provision of assisted reproductive services, and specifically noted the lack of any data to support the need of a father. And in 2005, around the same time, the HFEA ran, that's the Human Fertilization and Embryology Authority, ran a consultation document and published this Tomorrow's Children, this report. They didn't go into the issue of need for a father because that was already being taken up by Parliament, but they looked at whether or not providers felt that they had the tools they needed to actually make these child welfare assessments that they are required to make by law. So as a result of both of these two initiatives in the House of Commons and the HFEA itself, the law was changed, and the need of the child for a father was removed from the legislation, and instead the words were changed to say that the child welfare assessment should include the need of that child for supportive parenting. So you see that there, the replacement of the need for the father for the need for supportive parenting. So the HFEA, the authority, has defined this supportive parenting. It's a commitment to the health, well-being and development of the child. And they note in their guidance that it is presumed that all prospective parents will be supportive parents in the absence of any reasonable cause for concern that any child who may be born or any other child may be at risk of significant harm and neglect. And what I see here is a dialing back in a way of the obligation on providers. You are not in the UK supposed to necessarily make significant assessments of parenting ability, but really to be on the lookout for cause for concern that there will be significant harm or neglect to an existing child or a future child. And the HFEA guidance says that where centres have concern as to whether this commitment exists, they may wish to take account of wider family and social networks within which the child will be raised. And this, I really think, is a suggestion that providers look beyond the person who will be raising the child to look at their wider family network. And this is particularly important when the person has physical or mental disability, where we might be worried that they themselves are not going to be sufficient to provide supportive parenting, but that obligation is the centres are asked to look at their existing support structures around that person. The other thing that the HFEA has done, in addition to defining supportive parenting, is actually provide forms for clinics to use when assessing child welfare, and to lay out recommended procedures. So on the right-hand side is just a screenshot from a part of the form where they actually ask patients a series of questions about their history of violence and about their physical and mental well-being. So they also recommend that clinics have documented procedures so that they can show that they have taken account of the welfare of the child issue. They assess each patient before providing treatment and use assessment to decide whether a risk of significant harm or neglect is present. And if the child is not to be raised by the carrying mother, they should assess both the commissioning parents and the surrogate and the surrogate's partner in case there's a breakdown in the surrogacy arrangement. So that's interesting that they go that extra step there with surrogate families. So just pulling back now, if we look at what the UK does and we think about what the US recommendation from ASRM is, I think that making good policy and robust practices around this issue require really a lot of clarity about the different interests that are at stake in this kind of assessment, clarity and clear communication about the scope of providers' responsibilities, so their legal obligations and the ethical professional practices. So if I may be so bold, I would suggest that the guidance is not actually about child rearing ability, but about child welfare, or even more specifically the prevention of harm, significant harm. So I think there's a little bit of a misperception initially when you look at the guidance that you're trying to actually assess whether or not someone will be a good parent. I think the scope of the obligation is far narrower than that, and it's really to be on the lookout for indications that there is a risk of significant harm and neglect. So just being clear about the scope of the obligation and for providers and for their staff, I think is really important. We're not asking people to assess whether or not someone's going to be a good parent. which, by the way, is, I think, much more the kind of thing that adoption agencies are trying to figure out. Will someone be a good parent beyond will the child be at risk of significant harm, which is a much lower standard. And then I do think there's this interesting question about whether or not it would be good to develop or share more tools to help providers and their staff think through this issue, whether that be checklists or forms, prompts, questions, or training around case studies, and maybe some kind of feedback loop to hear from providers about how this issue goes for them and what kinds of practices they develop to deal with it. I know in the UK, in their report, they noted that providers have actually got various strategies for dealing with concerning patients that do not immediately involve withholding services. So things like asking patients to take some time out or get a second opinion, or referring them for treatment and then having them come back as ways of dealing with it, which is a little different from just withholding services. So there's various different strategies that could be shared. It would be good to know what people are doing. And then I just put here some questions for discussion and debate that I'm interested in. Is the proposed response to concerns about child-rearing ability, which is withholding services, is that just and effective? Is that the only response? Are there other responses available within fertility medicine for dealing with patients who raise these concerns? And as fertility medicine scope and reach expands, if we think about that fertility medicine, seeing more and more patients of more and more different kinds of patients, should providers seek to more deeply integrate into comprehensive systems of medical and social care for current and future families? And I think that's a really difficult question for fertility medicine. How much is fertility medicine sort of somewhat outside of large systems of care, and how much is fertility medicine to be integrated into systems of care? So how much would fertility providers be in contact with people who are treating patients for opioid addiction or other things that raise concern? So how integrated is fertility medicine into these other systems of medical and social care that the prospective parents might be needing, and what would need to change for that to happen? Yeah, so I've put here some of my citations that I have used, and happy to take questions, but as I said at the end of the final presentation.
Thank you. Ms. Reinhardt?
Okay. Hi, everybody, and I'm sorry for the little glitch in technology here. In the brief period of time that I have, I would like to share with you some of the legal considerations of child-rearing ability and fertility services. As I work as a consultant with private REI practices, I have nothing to disclose. Clear this? Okay. So some of the things that I would like to bring out this evening is some possible areas of liability, and it's based upon a discussion of some known legal cases involving child-rearing limitations. I'm going to look at some potential provider liability for limiting fertility treatment or for providing treatment that may cause subsequent harm. We'll also try to recognize some internal practices that may lead to future liability. And I'll take a look at giving you some guidelines for how to set up policies and procedures that will help minimize the risk for the practices when child-rearing concerns arise. I think before we can talk about the liabilities that may occur, we have to take a look at how we get to the belief that parenting is a fundamental right, as I think most of us in the United States hold. Many legal academicians and the courts have taken the position that parenting is a fundamental right, and it's granted to each of us by the Constitution. And way back in 1952, the U.S. Supreme Court stated in a custody case that a parent's right to their interest in their children was an interest that was far more precious than any property right. And later cases also stressed that the parent-child relationship gave you an interest that was undeniably warranting of more deference, and that absent any powerful countervailing interest, much more protection. Where was this found in our Constitution? Because you're not going to find it written that there's a right to parent. It's found under our right to life, liberty, and the pursuit of happiness in the Declaration of Independence, as well as in the Fourth Amendment's right to privacy and due process. But remember, however strong this position seems that we have a fundamental right to parent, we have to remember that all rights granted under the Constitution are subject to limitation by state or federal law if they're abused or if the harm to another person outweighs an individual's exercise of that right. Some experts say that the presumed fundamental right to parent free of state interference is overreaching and believe that the parental role is better interpreted as a trust model, which means that the state is entrusting a parent with the custody of a child's obligation to take proper care of the child. So to continue that thought, if someone abuses parental rights, or the harm to another would be too great if a parental right was allowed, parental rights could be or should be curtailed. And that touches on the topic that we're discussing tonight as to who gets to decide if your parental right should be curtailed. There are a lot of cases that support our rights to being parents, either at the state or federal court level. And we see it when we're discussing the custody of naturally born children, whether a state has the right to intervene in a parent-child relationship, and I think more importantly to REI providers, whether you have a right to parent children born of third-party reproductive techniques or to being allowed to use embryos created by assisted reproductive technology. It's in this latter category that we've actually seen the opposing view come out. And over the last 10 to 15 years, a large number of courts have wrestled with the fate of frozen IVF embryos in the context of a couple's divorce, which indirectly or directly decides who gets to be a parent or not parent. Most of the early cases argued for the right not to parent and won. But we're starting to see some changes on this theme, and they're using the advanced directives in couples' prior documents as either being dispositive or ignoring them. In 1999, a New York case used the prior agreement where the couple decided they would discard embryos, and the court enforced it. However, 1 year later, another court in Massachusetts ignored the advanced directive to let the ex-wife use the embryos and said that the party, the husband, who did not want to procreate, could change his mind and did. And today the courts still struggle with this issue, and couples' pre-IVF documents are becoming more and more important, but that's a topic for another webinar. One other unique and theoretical discussion often arises when talking about parenting rights and who should parent, and that's the concept of parental licensing. Arguably, anyone can become a parent. However, if parenting were considered a privilege and not a right, and it was looked at as having 3 criteria that we often use for licensing other activities, and that's it can be measured and regulated with having the potential to cause harm, that it requires a minimum standard of competency, and that there's a reliable way to measure the competency, we could consider licensing parenting much like we do driving. The major problem in this is in the operational application of this premise. How on earth could we regulate the competency of parenting, and even more problematic, how do we correct or punish people who don't meet that competency level before they even attempt a pregnancy? With this background, I think we need to focus again on the core issue for REI providers. What is our legal obligation to provide treatment to patients versus our obligation to protect a future child. In other words, what risk do we face in trying to weigh these dueling interests? Given that we also have to follow a multitude of laws and ethical precepts, I'm going to go through a lightning round of potential liability if parenting rights are limited or denied altogether. I've divided the possible legal causes of action into claims brought by potential parents and claims brought by the child or on behalf of the child due to harm or potential harm caused. I think the first area is easiest to identify or predict, and that's the claim of discrimination, which has been brought up by my other two speakers. Federal law protects certain classes of people from being discriminated against in our society, and they're identified as protected classes. These include persons who are legally protected due to certain characteristics, including sex, race, religion, color, or national origin, age, which means over 40 years old, and disability, physical or mental handicaps, which is what is included in that characteristic. Clearly, any black line rule that excluded any patient on the basis of these characteristics will trigger potential claims of discrimination. And in 2003, the REI community more about how discrimination played out for them when a patient, Kiwana Chambers, a single, blind, African-American lesbian, sued her fertility physician in the REI practice for discrimination because they denied her treatment to help her have a child. The clinic had actually done an extensive review of her living conditions, her support systems, her own compliance with care options before deciding to deny her treatment. She claimed discrimination, and 5 years later, the Colorado Appellate Court upheld the earlier judgment for the center, which found there was no discrimination. However, a later California case in a similar type of situation where a lesbian woman claimed she had been denied services due to her sexual preferences lost, and discrimination was found to be have occurred rather in that case. Based upon these cases and on a recurring question that I hear in my practice, I believe that the next characteristic or protected class that may trigger discrimination claim will be age. Frequently I get asked by practices and physicians, do I have to help a 62-year-old or older woman try to get pregnant? This just doesn't seem right. This question borders on the issue of whether a provider must render services that collide with his or her personal, religious, or moral beliefs. Our professional standards typically endorse a provider's right to step away or withdraw from providing a healthcare service that violates our moral or religious beliefs. But at the same time, these professional standards clearly tell us that there have to be limits to this right to ensure that patients receive the information, services, and dignity to which they're entitled. How you balance these competing issues can be the difference between avoiding or facing a discrimination lawsuit. The second area of potential legal risk to practices involves planning and or providing treatment that may cause harm to the child. In this instance, a provider may face numerous claims or causes of action. I'm going to give you just a brief scenario of some of the legal claims that may come up. The first and the most severe would be accessory to manslaughter or murder. And this actually came about in 1995 when a surrogate brought a case against an IVF center. She had carried a child for a single man, and a month after the baby was born, the father was found to have been guilty of third-degree murder and endangering the welfare of an infant. The surrogate tried to blame the center for not teaching parenting skills. Another type of claim is called wrongful conception, which says, I never would have been conceived. And that, in a 2006 case, a child was born with cystic fibrosis after the parents had used PGD to avoid using affected embryos. The parents sued for failure to properly detect the abnormality, trying to blame the IVF lab for the error. A different type of claim would also be with regard to something that would not have happened if things had gone right, and that's a wrongful birth or life case. Again, in 2006, parents brought suit against clinic, saying they had been negligent in reading the report from amniotic fluid, which said that the baby was most likely not affected with cystic fibrosis. Relying on that report, the mother decided to continue the pregnancy, and unfortunately, the child was born with cystic fibrosis. All of these cases form under medical malpractice, and I've kind of listed out two separate causes of action. One is lack of informed consent, which says if you had told me all of the information I needed to make a decision, I would have made a different decision. And an example of this was a lack of informed consent claim that came forward in 2005, where a clinic ended up paying child support because a child was born through a frozen embryo transfer and the father had never given his consent to the procedure. Even though it's at the end of my slide here, I think that where we're going to see a new frontier in legal liability is in genetics. And that's because of all the advances in genetic testing and the information that we have available. And some of the causes of action we may have seen already as wrong or misdiagnosis or errors in testing, but I think we're going to be seeing even more regarding to failure to inform of available testing, failure to inform of test results regarding the tests, and or failure to warn others of the test results, meaning others in the family who may be affected at a later date. We've already seen some of these cases where there's been missed reporting or failure to recognize a risk. And just one example, in 2006, parents had a child born with thalassemia. The doctors had tested the father and learned that he was a carrier, but even though they knew the mother's descent gave her a predisposition to be a carrier, they did not test her. Ultimately, all of these cases impacted the right to parent, or more importantly, the right to parent as we want it. And I think it puts practices on notices for what they need to know and what they need to tell their patients. So what do we look at when we're doing risk assessments for REI practices with regard to how we look at our patients and their child rearing abilities? Whenever I'm asked to do a risk assessment for any type of issue for a practice, I always look to any laws that are enacted, any professional guidelines that are available, and to any legal cases that are on point. And also at the underlying legal principles that may impact how we take care of our patients. In this area of child rearing, I think we have some really good places to go, and the applicable guidelines include the ASRM ethics statement on child rearing. It tells us that you may withhold services if you have well-substantiated judgments that the patient is not going to be able to provide minimally adequate or safe care for their offspring. We have to balance that with some of the other ASRM ethics statements, and I've pointed one out here that tells us that we have to treat all requests for assisted reproduction equally, without regard to marital partner status or sexual orientation and gender identity status. But I'm also going to add, we know we have to avoid any of the protected classes that is covered under our constitutional law. We also consider that physician will owe a duty of care if a physician-patient relationship exists or if you're contractually obligated to provide care to a patient. But otherwise, you can say no. And in certain circumstances, you can if the child-rearing ability seems to be questionable. But how do we get to that? And how do we know if what you're doing is actually something that is acceptable and is going to bear up to legal scrutiny? So what do I ask? I ask the practice, who do you deny access of care to and why? And what criteria are you using? Do you have blanket rules? Or do you have policies? Do you have guidelines? Do you have laws that is backing up the criteria that you use to accept or reject patients? Similarly, how do you assess child-rearing ability? Is it objective? When do you decide to provide, deny, limit, or end treatment? Is it done initially when you see the patient, or is it done after a certain type of process? And if you have a process, which I hope you do, what process are you using to reach a decision to treat or not to treat based on child-rearing ability? Finally, what process is used to reach a decision to deny treatment based on potential harm, which is different from the process you use to reach the decision to treat or not treat? And finally, is there a method for periodic process review? In other words, you go back and look at how you ask these questions, how you get the answer, and how you make the decision. And while I not have enough time to give you a specific policy, I think I can give you some tips for how to reduce your liability when you write your policies. Remember, our goal is to take care of our patients and to give them information that is necessary to provide them with what they need to make an informed decision while recognizing we have a societal and professional obligation to do no harm. Always, always integrate any available ASRM ethics statement into your policy and any state or federal laws that are on point. Use objective criteria for assessing your child-rearing capabilities. It's so often easy to let some of our subjective feelings and our biases color how we treat patients, and that's why things have to be kept extremely objective. Apply any of patient selection processes or review indiscriminately and fairly. And as mentioned by the other speakers, include multiple professional disciplines in your review process. We all bring different skill sets, and they're all necessary to making a good decision. Objectively document all your data that's relevant to your selection process, to your concerns, and to any interventions that you have provided, because we never know when we may need to bring those out later as proof of what we've done in trying to provide the best type of assessment and in making our decisions with regard to whether a patient has some true issues with regard to child-rearing capabilities. And if I can go back to the case I talked about in Colorado, it was because they used a very fair patient selection review. They included multiple professional disciplines in their process, and they documented everything that they did, that they were able to get through that entire legal claim and have it come out positively for them. Adopt and enact any of your interventions consistently. And I think most importantly, even if you're going to deny treatment, you can provide for follow-up support for the person that you haven't accepted yet, or for perhaps the patient as needed. Just because you decide not to treat doesn't mean that you don't refer them to the help that they may need. In summary, it's easy to see that law and ethics are still struggling with assisted reproductive technologies, and the law is generally behind whatever our technology is allowing us to do. Our individual morals deeply impact our compliance and how we react with our patients. Multiple parties' interests and technologies often complicate and/or change our decisions, which is why a written process and policy is so helpful in dealing with these very sensitive issues. And I believe that our obligations to do right extend not only to the patient, the practice, and the society, but to potential children and to ourselves as REI providers. And as I often tell my staff when we are faced with hard decisions, the harder thing to do, even though it might be more work, is often the right thing to do. Thank you very much, and please type any questions that you have in the chat window to the bottom of the gray navigation pane.
Thank you very much. We have a little bit of time for questions, so I'll start with the first one, and this is an open question to any of the panelists. We had an attendee ask if you would comment, please, on a recent case in the news about Kathleen Steele, who had 3 children with ART, her first at age 55 and the last at age 62, and the oldest child killed the infant, the youngest child. And a lot was made in the media about the clinic's responsibility of not being aware of her lack of social support as a single parent. Would one of the panelists care to speak about this case and maybe some of the things that could be done differently to avoid situations like this?
So this is Josie. I don't know that case actually, so I will look at it. But I do think that it's easy for ART clinics to be the scapegoat for much larger social problems. So I don't know enough about this to know whether or not there were signs early, when she was using the treatment, that she would, that there was a risk of significant harm to the child if she would become a parent again. But I do think that someone like this, there may have been other social services that she should have been able to access and wasn't, and that, at that point it's not the ART clinic's responsibility, but the fact that there weren't sufficient supports for this person as a sort of general matter in society. So I was worried about scapegoating ART providers where there are much larger problems in this healthcare system and social welfare system in the US that may have been partly responsible.
This is Lisa, and I think that that goes to one of the questions that I brought up, and should there be restrictions placed on mothers of older maternal age? I agree with Josie in that it's very easy to place the responsibility on the clinic because they want someone to be a gatekeeper. And physicians that I've talked to have gone both ways. In one practice, I've had physicians say that if we're not looking at age and who should parent, then who will? And their colleagues sitting right next to them saying, but who are we to restrict anybody's right to be a parent? I think the best we can do in that is just be open to any discussions that the patients may have with staff. I was actually involved in a similar case where a physician had helped a 62-year-old woman get pregnant, and she called one day regarding her appointment and how she couldn't make it and just started crying that just being pregnant was too stressful for her. And we referred her to several social services that helped support her. Fortunately, that ended up okay, but it could have ended up just as badly.
But so in this Kathleen Steele case, I'm just not sure that from what you just said earlier, or what was said earlier, that her age has really anything to do with it, or that she's a single mother. It sounded like the problems are not related to her age, but to the fact that she had a violent existing child, and it sounded like maybe she also didn't have sufficient resources, or I'm not sure. Like, I think it's easy to get to think of something that's up to see all these various problems with this family, and which ones were the ones that really caused the problem.
Thank you very much. My next question is actually for Dr. Westphal. What should be included in a clinic policy about child rearing ability from a provider's standpoint?
So I think one of the last couple of slides was very nice in how to put together a policy, but the clinic policy, should include what type of evaluations will be done, what type of conditions may preclude going through with infertility treatment, what the procedure is for assessment when there are questions, such as when to, use a mental health professional or another type of consultant, and, and make sure that everything is done as a group decision. So to be very careful that there's no discrimination or bias in the final decision.
Thank you. This is a question that was raised actually during one of the presentations. Dr. Westphal or Ms. Reinhardt, do you have any idea how often the programs actually withhold services because of concerns about child rearing ability?
I think there aren't, obviously we don't have a lot of good data. One of the articles that looked at it in the past, so Andrea Braverman and a couple of her colleagues published in Fertility and Sterility. They asked a number of programs how many turned away patients, and programs said that about 1% of their patients they turned away for emotional, social, or psychological reasons. So it's not a common occurrence, but it is something that I think most programs do have to deal with on occasion.
And I think that's what I've seen is you don't see a lot of data. It's anecdotal, and it's generally a handful of patients. They tend to stand out, so they get a lot of attention, but I don't think it's an everyday occurrence.
We have time for one last question. And this one's for Ms. Reinhardt. You talked a little bit about genetic testing could be a source of future lawsuits. And how can a provider avoid liability in this area?
Sadly, I can never say that you can completely avoid liability. We live in a pretty litigious society, and if a patient wants to bring a claim, they will probably find someone who will bring it. Though I think the best way to reduce any possibility is to keep up with the technology and the availability of genetic testing. And that doesn't necessarily mean that providers need to learn all this themselves. There are a lot of genetic counseling services out there that are very, very helpful. Incorporating that as a routine part of your practice, to me, is key to reduce liability. Share information with your patients appropriately, and make sure that any genetic issues that may affect third parties, such as other children, etc., that they've got the information they need to pass it on. The other thing that I always tell practices is make sure that when you're getting testing done on patients, that you have a reliable process for making sure that you get the test results back and that test results get to the patient. Some of the cases that we've seen, the problems have been because testing wasn't reported, or it wasn't reported in a timely manner. So it sounds like it's a given, but it doesn't always happen, and those are the ones that you'll hear about later through a lawyer.
Thank you very much. I'd like to thank all our presenters and attendees. The session was recorded and will be available on our website in the near future. Please keep an eye out for the announcement of our next webinar topic. For any further questions or comments, please don't hesitate to reach out to me at asrm@asrm.org. Attention, Jessica. This concludes the webinar.
Thank you, Jessica.
Thanks.